This is Duke University.
As you saw, today's discussion is centering on the Kiobel case that was heard earlier this term before the Supreme Court. Kiobel presents the issue of whether a corporation can be held liable under the Alien Tort Statute for human rights abuses committed overseas. In Kiobel, Nigerian plaintiffs accuse Royal Dutch Petroleum, commonly known as Shell, of complicity in the arrest, torture, and killing of protesters by government forces in Nigeria. So to discuss the case and help you understand a little bit more about what's going on in the case, we have three excellent speakers today. First, we'll hear from Professor Bradley, who is the William Van Alsten Professor of Law and Professor of Public Policy Studies here at Duke. His scholarly expertise spans the areas of constitutional law, international law, and foreign relations law. He is the author of International Law in the U.S. Legal System, published earlier this year, and was recently appointed as one of the 8 reporters for the Restatement Fourth of Foreign Relations Law of the United States. He teaches foreign relations law, international law, and federal courts, among other courses. Next, we'll hear from Professor Helfer, who is the Harry R. Chadwick Senior Professor of Law and an expert in international law. His scholarly interests include interdisciplinary analysis of international law and institutions, human rights, and international intellectual property law and policy. He is co-director of the Center for International and Comparative Law here at the Law School and a senior fellow with Duke's Keenan Institute for Ethics. He is the author of the 2011 publication, Human Rights and Intellectual Property, Mapping the Global Interface, and teaches courses in international law and international human rights law. And third, we'll hear from Professor Orshi Jaffour, who is a professor of political science and public policy at North Carolina Central University. He was the director of international affairs at the university from 2005 until 2012, and is currently serving as the chair of the Department of Political Science. He is also co-authoring a book currently on democracy, governance, and economic growth in sub-Saharan Africa. His teaching and research interests include the political economy of developing states, public policy, and international development. And after we hear from our 3 speakers, we'll try to make sure we have some time for questions and answers. So without further ado, Professor Bradley.
Thank you. And thanks to all of you for coming. What I'll do is I'm going to describe the legal issues specifically posed in the Supreme Court case, the Kiobel case you just heard about, and then we'll turn to some broader international and other issues in the subsequent talks. So the Kiobel case concerns an old statute, in fact, a statute that dates back to the founding of the United States. It's called the Alien Tort Statute, 1789 statutory provision. It's still one sentence long. It's always been just one sentence, and it says, "The district court shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States." So something about aliens suing for torts in violation of international law. For almost 200 years, basically the statute never gets used. It just is buried in the statute books from 1789 until 1980. And in that year, the U.S. Court of Appeals for the Second Circuit issued a landmark decision. It's a decision called Filartiga versus Peña-Urala. And the Second Circuit holds that victims of human rights abuses in other countries can use the statute to sue the perpetrators of the abuse in a U.S. court if they can get personal jurisdiction over the defendant. In that case, the Paraguayan police inspector defendant happened to be residing in the U.S., so they were able to serve him with process. The case concerned the torture and killing of one of their family members, the plaintiff's family members, down in Paraguay by the police inspector. And the court basically said, after all, these are suits by aliens, these are Paraguayan plaintiffs, for a tort, torture and killing certainly is a tort, in violation of at least the modern law of nations, international law which forbids torture and summary execution. Since then, that landmark decision, there have been a wide number of cases from all over the world coming to U.S. courts involving atrocities, human rights abuse, from almost any conflict zone you can think of. There's been a U.S. court case initiated concerning it. The U.S. Supreme Court has been relatively silent during this period. This has now been over a 30-year period of litigation. Its one intrusion into the area came in a case called Sosa against Alvarez-Machain in 2004. Kind of an odd case involving a U.S.-sponsored kidnapping of somebody in Mexico and the war on drugs. We don't actually know a lot from that decision. It was one of the more cryptic Supreme Court cases, great for lawyers and law professors because nobody knows what it means. What it appears to at least mean is that the majority of the court in Sosa found that at least some human rights claims can be brought under the Alien Tort Statute. It refused to kind of close down the litigation that had been going on at that point for 24 years. But other than that, it appeared to say little about who exactly could be sued under the statute, which kind of defendants, and the territorial scope of the sorts of claims you might bring under the statute. And in fact, in that case, the claims were about arbitrary detention of the person who was kidnapped. The court dismissed those claims as not rising to the level of enough agreement internationally on the law and enough specificity to allow you to have an Alien Tort Statute claim. So it's clear the court wanted the lower courts to scrutinize these claims pretty carefully. And it also said something, again, quite vague about how courts should take account of the practical consequences of allowing litigation from abroad into American courts. But quite vague directions, and lower courts really haven't known what to do about it, and by and large, the litigation has continued to grow since 2004. One thing you should know about this area of law, it's not legally possible to sue the abusive foreign government itself. That's actually true under U.S. law or international law. It turns out governments have immunity in other nations' courts for even human rights abuse that they commit within their own borders. The International Court of Justice has held that about international law, and there's a statute in the United States that gives foreign governments immunity. So in the Florida case, you couldn't sue Paraguay for the torture. It's just not allowed under U.S. or international law. So they ended up suing the police inspector because they couldn't sue the government itself. And that was the general strategy for a number of years after Florida. You go after the individual prison guard or military leader or somebody who's in charge of the, allegedly in charge of the abuse. One downside of doing that is you almost never get any money. If you're trying to get compensation or punitive damages, they almost never have assets, those sorts of defendants, certainly assets that you can reach from a U.S. court. So those judgments might be something the plaintiffs would like, which is some kind of vindication of their rights, but not one that typically involves any compensation for their damages. That started to change. The lack of a possibility of monetary relief started to change in the mid-1990s. And around that time, plaintiffs started bringing cases in U.S. courts not against the foreign government officials, but rather against multinational corporations that were doing business in these abusive places. And generally the suits allege that the corporations somehow have aided and abetted the bad human rights practices of the local regime through a variety of possible ways, giving them materials that might have been used in the abuse, benefiting, knowing about and benefiting from the abuse, encouraging potentially the abuse to protect their security at the oil plant or something like that. A bunch of different possible scenarios in which the corporations allegedly somehow kind of facilitate or encourage the governments to conduct abuse. And those suits then really started taking off in the mid-1990s. And that's the Kiobel case. It's one of these many corporate cases. A group of 12 Nigerian plaintiffs who had actually come to the United States and obtained political asylum sued Royal Dutch Shell, the Dutch corporation, but also a British corporation. Ultimately, the allegations were that through their Nigerian subsidiary, they had facilitated or aided and abetted the Nigerian military's abusive conduct against protest movements, basically, in a regime in Nigeria during the 1990s that include alleged rape and killing and all sorts of terrible conduct. What happened, perhaps to many people's surprise, in this particular case in the Second Circuit, a circuit that had otherwise been pretty encouraging of the litigation, is that the Second Circuit, unlike all the other courts that had addressed these corporate cases, held in Kiobel that in fact you can't sue corporations under the Alien Tort Statute. Their reasoning was that the statute requires a tort in violation of international law, but that international law, according to the court, the Second Circuit, doesn't actually cover corporate human rights conduct. And they noted, for example, that if you look at the international criminal tribunals, like in the ICC, it doesn't cover corporations actually on purpose. It only covers natural persons. If you look at the human rights treaties, again, they have typically covered only natural persons, not the regulations of corporations. It was a very divided opinion. It was 2-1, and the dissent had strong disagreement with what I just said. And the dissent's basic point was, as long as you can find conduct that violates international law, in this case the rapes and the torture and the beatings and the killings, the issue of who can be sued should really be more of a matter of U.S. law, not having to find it in some kind of a treaty or international law. And there's been a long settled tradition in the United States, of course, of being able to sue corporations for torts. So the dissenting judge said we should find that there's an international law violation and then allow corporate liability under kind of a U.S. law tradition of corporate suits. Well, that was the dispute, and the Supreme Court agreed to take the case. The case got even more unusual after that. People were all waiting a year ago for the court to hear and decide this case on corporate liability. A huge question because many, maybe even the majority of Alien Tort Statute cases in the last 15 to 20 years are the corporate cases. That's where there's a possibility of getting money against the defendant because most big corporations have assets in the United States. They're willing often to settle these cases so they don't have bad publicity. And a lot of the cases we're now having this corporate type defendant. The Supreme Court agreed to take that issue a year ago, had oral argument, and then took the very unusual step of ordering the parties to conduct additional briefing and have a new argument the following term, this past October, on a second question. And the second question is, does the Alien Tort Statute even apply outside of the United States? And I think that development in the court was quite surprising in the sense that all of the cases from 1980 on in the lower courts had pretty much assumed you could sue for foreign human rights abuse outside of the United States, even by foreign defendants and brought by foreign plaintiffs. So the lower courts had just assumed this regime was extraterritorial. The Supreme Court's now asking the parties, is that in fact true? The Supreme Court itself had not directly addressed the issue. It had just been the lower courts. So now we have before the court the issue, does it even cover corporations at all as defendants? And second, does it, and if so, how much, does it apply outside of the United States to, for example, torts in Nigeria committed by non-U.S. citizens, Nigerian citizens? Why the surprising extraterritoriality element injected in the case that's so different from what the lower courts have been doing? One observation I'd make about that is that the litigation had really been expanding, as I indicated, in recent years, to include, for example, a lot of these new corporate cases. And what happened in those cases was an increasing degree in which U.S. courts were linking international law ideas about torture, for example, being an international law, with domestic law standards. What's the test for aiding and abetting? Courts were drawing that out of U.S. domestic law. Corporate liability, as I've already mentioned, perhaps being drawn from domestic traditions, not particularly from international law. The more those cases looked like U.S. courts taking U.S. law ideas and pushing them into Nigeria or Burma or these other countries, the more it seemed like an extraterritorial reach of U.S. power and jurisdiction, and the more this issue seemed to be bubbling up to the surface, and the court clearly caught the court's attention. So two issues. Can corporations be sued for these human rights cases under this old statute? And second, to what extent can you sue for anything that occurs outside of the United States? Another very interesting feature of these cases is to watch the position of the U.S. executive branch, the State Department, the Justice Department, because they often have a very big interest in reciprocity, for example, with other countries, how other countries get irritated if they do about these cases. The first round of briefing on corporate liability, the executive comes in, State Department and Justice Department joining together, saying, no, we don't think there should be a ban on corporate suits. If you can sue natural persons, we think it's probably only right that you could also sue corporations, supporting the plaintiffs. They filed a brief on behalf of the plaintiffs. New briefing ordered this summer on extraterritoriality. Lo and behold, the executive branch files a new brief on behalf of the defendants, saying, in fact, that at least in a case involving foreign government actors and foreign foreign victims, involving this kind of aiding and abetting claim, which is what's going on in the Kiobel case, aiding and abetting these abuses, the executive branch said, we don't think the statute should apply to those foreign kind of activities, in this sort of case at least. Interestingly, if you look at the brief, only signed by the Justice Department. State Department noticeably not on the brief, very likely signaling there was a dispute within the executive over that extraterritoriality question, but the Justice Department ultimately decides on filings in American courts, so the Justice Department position was the one that was presented to the court. So the Supreme Court had a second oral argument this October at the beginning of their term, and some people ask me, what is the court going to do? Fortunately, my salary doesn't depend on making those sorts of predictions, and this one particularly would be a dangerous one to predict. What do I hear most people saying on both sides? I hear a lot of people thinking that there will be some cutback in the breadth of the Alien Tort Statute litigation from the tenor of the two arguments. And the fact they asked for all of this briefing and the like seems likely true. How much of a cutback, obviously, is much more important a question. The plaintiff-oriented community hopes it's along the following lines. Some kind of modest requirement that plaintiffs in these cases exhaust local remedies when that would be feasible. And by the way, if you're in danger of your life, if you sue in Nigerian courts, not feasible. If it would clearly be futile because there are no remedies in Nigerian courts, not feasible, and therefore there'd be no limitation, at least according to the plaintiff's side, in those cases. But some kind of an exhaustion of remedies, plaintiffs would hope that it would not be too strenuous to meet before you could sue in the U.S. And a number of the liberal justices on the Supreme Court clearly seem to incline in that direction. Greater restriction would be something like the executive branch has suggested, that at least when it's foreign government activities, foreign plaintiffs, and at least in kind of an aiding and abetting indirect liability case, we don't apply the statute abroad. That would be a much more significant cutback, but the fact that the government supported it gives it some possibility it'll be adopted. All the way to the possibility, although I think unlikely, the court would say, we don't think the statute applies outside the United States at all. That would be a surprise if they went that far. Part of what happens, I think, on all of that is to what extent the Supreme Court thinks that other limiting doctrines, like forum nonconvenience and there's something called the act of state doctrine and the political question doctrine, whether those doctrines might do enough already to protect American foreign relations from complaints and friction with other countries. If you think those doctrines are not very strong, the court might be more likely to cut back the statute in other ways. But if it thinks those doctrines can work enough to protect our relationship with other countries, it might not want to do as much to the Alien Tort Statute. It's also possible, despite the new issue, that they will cut back on the idea of suing corporations at all, like the Second Circuit. But most people don't think that will happen in any significant way. But again, it's very unclear from the oral arguments. I think the plaintiff community was very discouraged after the first oral argument, when it's clear that a lot of the Supreme Court justices were skeptical about this whole idea of America sitting in judgment on human rights abuses from around the world. Where did we get the right to do that? Isn't this going to generate complaints from other countries? In fact, it was. Great Britain and the Netherlands, though, of course, their corporations are being sued in this case, filed a brief saying they were very unhappy with this litigation. And Justice Kennedy and some other justices were quite concerned about those friction issues with other countries. So the plaintiff community, I think, was very worried after the argument, and then they asked for briefing on this big issue. Does it even apply outside the United States? I think it's fair to say the plaintiffs got a little more happy after the second argument, when it was clear that nobody on the Supreme Court seemed to know what to do with the case. It just seemed to be rampant confusion in the questions. And therefore it wasn't as clear they were going to cut back on the statute, because they were all groping around to try to figure out what would make sense. Often the case, really keep your eye on Justice Kennedy. He's likely to be a key pivot vote on this, as he is in other cases. So the last thing I'll say about that, just keeping an eye on what he said, it looks like he wants to keep the Florida case intact. Just a Second Circuit case, not a Supreme Court case. But it's been around a long time, and the human rights community certainly has viewed it as a core part of the human rights developments in U.S. litigation. And what he asked was, can we keep that case allowed? That is, when somebody's residing in the United States, like the police inspector, or it's a U.S. citizen being sued, or a U.S. corporation, can we let that happen, but then disallow suits against individuals that don't have any ties to the United States, or foreign corporations that are just doing conduct abroad? And he looked like he was searching for some kind of distinction that would keep some of the Florida cases alive, but not these purely foreign corporate or other cases as viable. So it's possible he'll end up having a key vote on that. So we'll see if my prediction comes true or not.
Well, that was great. So Professor Bradley's given a really insightful overview of the important and complex litigation issues at stake in the Kiobel litigation. And I want to try to situate the case in a somewhat broader perspective. And in particular, I want to do two things, and that is talk a little bit about how the Alien Tort Statute and ATS litigation is viewed from outside the United States, from the perspective, in particular, of international lawyers, and also to focus in on what other judicial venues exist, judicial or otherwise, for human rights lawyers and their clients to seek remedies for violations of international human rights law. I should say that's going to be important regardless of how the court in Kiobel rules. And as I'll mention, there are a number of other cases that are currently ongoing or recently decided involving the very same alleged abuses, human rights abuses, and violations of international law in the Niger Delta in other venues. And so this is happening, these alternative strategies for seeking remedies for human rights violations. And the question is, if the ATS statute survives in some form, how would these other remedies interact with the ATS? And if it doesn't, those other remedies are going to be even more important. Okay, so first I want to talk about the external view of the ATS from the perspective, for example, of a European lawyer or commentator who is looking at this litigation with an eye to international law trends and rules more broadly. So within the US, I think it's fair to say that the ATS is celebrated by many lawyers, by many legal scholars, as a potent domestic mechanism for enforcing international law. That's one of the reasons that it's so attractive. It is deeply anchored, as Professor Bradley mentioned, in the US legal tradition, goes back to the founding, notwithstanding the fact that what the statute actually means is somewhat of an open question, but it seems to provide what is often missing in international law, which is a domestic jurisdictional hook for bringing these sorts of cases within domestic courts. And if you think about it for a moment, to the extent you are suspicious of international rules or institutions, courts, review bodies, what have you, as being weak, if you can get domestic enforcement of international rules, that's going to strengthen the international legal system and, in the area of human rights, strengthen the promotion and protection of human rights. But for lawyers and commentators outside of the US, the ATS is kind of distinctive, even peculiar when thought about from an international law perspective. And I want to just highlight three ways in which I think the ATS is quite distinctive. And I want to suggest that these distinctive features limit the contributions that ATS cases can make to the development and enforcement of international human rights law. And they also very nicely implicate, I think, questions of other mechanisms for seeking relief for these sorts of violations, however the Supreme Court were to rule in Kiobel. Okay, so first, distinctive features. So by interpreting, at least so far, the Alien Tort Statute to permit victims of human rights law violations to sue for damages no matter where the injuries occurred or by whom they were committed, U.S. courts are exercising a form of universal civil jurisdiction that, in truth, is not well established either in international law or in state practice. There are some analogies that can be made to civil actions that are appended to criminal prosecutions. This happens quite a bit in Europe. But those statutes are not that many in number, and they are different than the ATS in that they're linked to the restrictions and other sorts of procedural rules that attach to criminal jurisdiction and very often will require a criminal judgment, which, as you all know, is subject to a higher standard of proof. So the ATS is a form of universal civil jurisdiction, and most U.S. courts, as Professor Bradley mentioned, have really not considered this question. They look to the Restatement Third of Foreign Relations Law of the United States, which says that, yes, this kind of jurisdiction is okay. What authority does the restatement cite? Well, primarily the ATS. So there's a little bit of a kind of feedback loop there going on. And this has gone on really for 25 years since the Filartica case, and now this issue is fully joined in Kiobel. As Professor Bradley mentioned, a number of foreign governments have weighed in with amicus briefs to explain, in fact, that a broad construction of the ATS in certain ways might very well be, would be, let me be more clear, an excessive form of prescriptive jurisdiction contrary to the rules of prescriptive jurisdiction in international law. So that's one distinctive feature. The second goes to the nature of the claims that can be heard. So the statute on its face appears to permit tort claims for any tort in violation of the law of nations. But the U.S. Supreme Court in the Sosa decision that Professor Bradley mentioned interpreted this provision more restrictively, limiting it to violations of international law rules that, I'll now oversimplify a bit, are universal, obligatory, and specific. So that's the current standard, universal, obligatory, and specific international norms. Now, this standard is distinctive to the U.S. legal system, and it has an uncertain relationship to other key international law doctrines. So, for example, the standard is narrower than customary international law, which requires widespread and consistent state practice, but not universal state practice that is followed in the belief that it's legally required. Similarly, the universal, obligatory, and specific standard is probably broader than jus cogens, those peremptory norms of international law from which no state is, in principle, permitted to derogate. And so, as a result of these differences, it's somewhat uncertain what precedential value ATS decisions have in helping to develop unsettled or emerging international legal norms. So that's the second difference, the substantive standard. The third goes to gap filling. As many of my former students are in the room and they know all too well, international law is not a complete legal system. It has gaps and omissions, lacunae, if I want to be fancy about it. And this is especially true with regard to its secondary rules. And international law looks to domestic legal systems to fill those gaps, albeit in ways that are consistent with international values. But U.S. courts have really struggled with how much gap filling the ATS allows, not the least because the ATS is not merely an international enforcement statute, it's an enforcement statute that's deeply inflected through U.S. foreign relations law and all of the sorts of doctrines that Professor Bradley has mentioned. So because U.S. judges are uncertain of their role as gap fillers, Congress hasn't told them, the Supreme Court hasn't told them, they've reached quite inconsistent decisions in the lower courts, not only over substantive issues like whether plaintiffs can sue corporations and the knowledge required for aiding and abetting liability, but also over just basic choice of law questions. Do we answer those substantive questions by looking to U.S. law, to international law, or some hybrid of the two? And the answer is we don't know, and we'll get some clarity, I think, from the Kiobel case, but maybe not in all respects. So in sum, these three distinctive features reveal, I think, that the ATS suits, far from just enforcing international law, have allowed U.S. courts to stake out a fairly aggressive position on universal civil jurisdiction. Now, whether you think that's a progressive development or a regressive one is going to depend on your viewpoint. But it's no doubt the case that the courts in the U.S. have done this by applying a kind of eclectic mix of American and international standards that may not really contribute to the development of international law. Okay, so second part of my talk, what other options are available then, depending on what happens in Kiobel? And I want to just highlight two recent court proceedings, both of which involve violations of human rights and international environmental law in the Niger Delta region of Nigeria. So the first case is a subject of research that I have been doing over the past couple of years, was a suit filed by an NGO based in Nigeria known as the Socioeconomic Rights and Accountability Project, or SIRAP. And the complaint they filed was with a court I'm confident that almost all of you have not heard of, the Court of Justice of the Economic Community of West African States, or ECOWAS. Now, this court started out its life as a kind of international economic law court, but in 2005, the member states of the West African subregion gave the court a broad human rights jurisdiction to adjudicate complaints filed by individuals and NGOs against West African governments. And the court has since issued quite a few judgments just in that short period of time by governments that previously had not been brought before international courts or tribunals. So the court, by the way, sits in Abuja, which is the capital of Nigeria, although it can hear cases from many other countries, and indeed it can actually move to those countries to hear cases. So in 2010, SIRAP, this NGO, files a complaint with the ECOWAS Court against the federal government of Nigeria, against many of its officials, and against a number of the multinational oil companies that were involved in the environmental degradation of the Niger Delta. And they allege a range of international violations of internationally recognized human rights, including some that would not pass, I will say, the SOSA test of obligatory, universal, and specific. So some of the claims include the right to an adequate standard of living, adequate access to food and health care, to clean water, to clean and healthy environment, and the right to life and human security and dignity, all of which are in fact protected in regional and global human rights treaties, but most of which I think have been rejected even before in early ATS litigation as not being sufficiently well established. And the complaint alleged two things, to oversimplify: that the oil companies did not adequately respond to oil spills in the region, causing harm to the local population on a widespread basis, and that Nigeria did not properly regulate or remedy the situation and in effect turned a blind eye to the oil companies' destructive practices. So here is a court based in Nigeria hearing very similar claims, indeed more expansive claims in some way, than were pending in the Kiobel case in U.S. courts. So the ECOWAS Court has issued two decisions in this case. I think they're both interesting, and I'll just highlight them briefly. The first was a ruling, an interim ruling in 2011, in which the court dismissed the corporate defendants, the oil companies, from the suit. And they said, you know, we look at this from a somewhat different perspective. We're an international court. And they said, to quote them, one of the paradoxes that characterizes international law at present is the fact that states and individuals can be held accountable internationally while companies cannot, citing the Second Circuit's decision in the Kiobel case. Now, the court did note that there were growing demands to change this rule, and they cited a variety of different sources in support of that, including other ATS cases involving corporate aiding and abetting liability. But the court said, look, at the present state of international law in its evolution, it hasn't arrived yet at the point where claims against corporations can be brought before international courts. So just to clarify, when Professor Bradley said, when he was referring earlier to what you can do before foreign courts, there's a third venue, international courts, and those have different jurisdictional rules. And that became very important because although the ECOWAS Court dismissed the oil companies as defendants, it kept the Nigerian government defendants in the suit. And in a judgment issued in December of last year, so just 2 months ago, the court held that Nigeria had failed to regulate the oil extraction industry in the Niger Delta and thus was responsible for the damages that the companies had caused. And it ordered the government to take all effective measures to ensure the restoration of the environment in the Niger Delta, to prevent the occurrence of future damage to the environment, and, in language that I think is going to be the subject of future litigation, to hold the perpetrators of the environmental damage accountable. So, here again we have a court that is allowing suits against the government defendants, but not the corporate defendants. Whereas in U.S. courts, you could, until now, arguably bring suit against the corporate defendants, but not under doctrines of sovereign immunity or active state against the government defendants. That's a distinctive feature of the fact that the governments of West Africa have recognized the jurisdiction of the ECOWAS Court, and by the way, of other international human rights courts and review bodies. So, in the just minute or two remaining, I'll just mention briefly a second case just decided last Wednesday where a court in the Netherlands ruled that a Nigerian subsidiary of Royal Dutch Shell was responsible for oil pollution in the Niger Delta, and it ordered that subsidiary to pay damages to only one of several plaintiffs. But it did nevertheless. This was apparently the first time that a Dutch company had been sued in a Dutch court for harms allegedly caused by its foreign subsidiary. And the question that is now open is whether other Nigerians from the Delta may be able to sue in the Netherlands. So just to sum up, what does this mean going forward in terms of what happens in the Kiobel case? Well, I can see sort of two broad pathways forward. One would be if the ATS survives in some format, which I think it probably will, I agree with Professor Bradley, then you might have a multi-pronged strategy by international lawyers to enforce these norms. You might be able to sue U.S. companies that were complicit or aided and abetted or actually perpetrated violations in U.S. courts, perhaps. You might be able to sue foreign companies in their home jurisdictions, the courts of their home jurisdictions, and the governments before international courts and review bodies. Now, that kind of claim splitting ought to raise hackles of any proceduralists in the room, right? But it also raises questions about exhaustion of domestic remedies. What sorts of remedies ought to be exhausted? Should they be all foreign litigation? Should it be foreign and international litigation against the same parties that can be sued in U.S. courts? All of these remain open to be resolved. Now, if the ATS statute is cut back substantially, then I think these other mechanisms become even more important. And these are nascent, fairly new mechanisms, and they need to be developed, and they need cases to decide. And in many instances, although not all, they are closer to the litigants and to the location of the harm. And there's at least, I think, a decent argument that there are human rights promoting values in having litigation and in bolstering institutions that are geographically proximate to where the harm occurred. Thank you.
First of all, good afternoon, and thank you for having me over here. And thank my esteemed colleague for very rich information in terms of the legal implications of ATS itself. Interestingly enough, I was just telling Lilia that I just began some work on the whole issue of the Delta State and the oil exploration and the implications in the Delta State. I am originally from Delta State, interestingly. Maybe she didn't know that. So I have a stake in terms of what's going on in the Delta region. Unfortunately, I haven't spent enough time in the Delta part of Nigeria because most of my mother's family are from Lagos, which is in the southwest part of Nigeria. So I grew up in Lagos, but I spent very few times in the Delta State. So somewhat, there's some emotional aspect of this case that perhaps bothered me. And even at that, I haven't done much work about the Delta State. I spent a good deal of time working on the issue of democracy and governance in places like Liberia and Nigeria, and of course South Africa as well, and Ghana. So this is very timely, and I really appreciate being here. And I've gone through this learning experience with my two colleagues here. What I'd like to do this afternoon, however, is to give the future barristers, I think in the British system, the barristers, and a lot of the socio-political context. Hence, I come from a family of a lot of lawyers anyway, so we tend to use that British term, barristers and solicitors. Anyway, I would like to give the socio-political context as a political scientist in terms of what we see evolving out of the ATS case, the Kiobel case, which is coming up. Even interestingly, there's supposed to be a case coming up in The Hague very soon to address issues related to the Royal Dutch activities and atrocities in the Delta part of Nigeria. One has to understand the social political context along the legal context, and understanding those two perimeters give you a sense of why it may be necessary for the appellants or the perhaps the plaintiffs in this case to come before an international court or perhaps a national court to seek redress for the detrimental activities of Royal Dutch. In the Kiobel case, we are talking about Nigerians who are now seeking remedy from the U.S. court for the atrocities of Royal Dutch in Nigeria. Why not seek that redress in the Nigerian court? We need to really have a sense of what's going on in the Nigerian legal environment. And the Nigerian legal environment is actually dictated by the socio-political climate in the country. So the context for this will be that Nigeria became an independent country in 1960. Before 1960, there's been oil exploration in Nigeria as far back as the early 40s up to the 1950s. And by the 1950s, the big jackpot was hit. It was really quite confirmed legally and scientifically that, yes, there's presence of oil there. So 57, 3 years later, we attained independence. But the state itself, the Nigerian state itself, has been a very, very interesting state. It has been a state that has gone through a pendulum of change in terms of its political processes. From 1960 to 1966, we had a parliamentary system. By 1966, we had the first coup in Nigeria, the first military coup. So there was a new change of government. This is a new, young country that is going through this experience that it wasn't quite ready for. But clearly, the military emerged. Then from 66 to 1970, 3 years straight, we had a civil war that devastated most part of the southeast part of Nigeria, which involved the Igbos and the rest of the Nigerian government at that period of time. And bear in mind that one of the factors that led to the civil war was this whole issue of federalism and the resource control, who gets what and how, and revenue sharing. So not to get into the whole discussion about fiscal federalism here, it is very, very clear that the new state called Nigeria itself, is a state that is quite weak. However, from 1966 to 1998, we've had various forms of military governments, counter coups and coups, failed coups, successful coups, whichever way you want to coin it. It was 32 years of military rule, and military rule, by its standard, anywhere for the most part, is very oppressive. So that's the political context which we have to understand what has been going on in Nigeria. Now, there was a civilian government that emerged in 1980. That civilian government, 1983 actually, 1980, so by 1985, that government did not last its second term. And then another coup took place. So there's a stopgap period here in terms of civilian rule. But between 1999 and 2013 up to the present, we've had about 14 years of stable democratic government, to say. But the question, it's questionable. The extent of democracy in Nigeria is very questionable. But what we do know is that we had a democratic transition, and it's been very stable between 1999 and 2013. But the practices in terms of that, in terms of the consolidation of democracy itself, it's very, very porous, and I'll get into that. But the social context for all this is that Nigeria itself is embodied by over 300 ethnic groups that speaks over 250 languages, over 1,000 dialects. So the creation of the nation states is based on some exogenous factors: colonialism, decolonization. Then we were all amalgamated from north, south, east, west together. People have called for maybe a decentralization, a secession, and so on and so forth. But the point I want to make is that in the 53 years history of Nigeria itself, the state itself is faced with enormous challenge. And that is the challenge of how to bring about democracy, good governance, and rule in Nigeria. That's been very impossible in Nigeria. The whole issue of democracy has become an elusive goal. It has become an elusive goal because when you have governments that are irresponsible, unaccountable, it becomes very difficult to seek redress, as some of the plaintiffs have come to seek under ATS. So the ATS itself gives the appellants and the plaintiffs, as we say in America, in this case, an opportunity not only to seek redress for what has happened in the community. This is a community in the Delta region where 94.5% of Nigerian export is oil revenue. They get very little from this export. In other words, whatever receipts come from oil revenue, it's not reinvested into the social, economic lives of the people in Delta State. So there's a lot of frustration that's gone over the years. Then on top of that, they've had some of their leaders killed, assassinated for the most part. One prominent one was, most of you probably know, was Ken Saro-Wiwa in 1995. So you have a 5 decades of basic abuse and exploitation in the Delta region itself. So you have an emergent radicalism and, of course, opposition from young people who have never had opportunity to get basic, fundamental social infrastructure such as schools, good roads, good water. Remember, as much oil as they have in that Niger Delta area, it's also a very rich area for agricultural production. If you can't farm because you have spillages that have devastated your community, then you can't feed your people. So therefore, there's been a lot of frustration and opposition emerging from this community. What we see here, after all this has been said, I, from my own training, always often ask, what is the nature of the Nigerian state itself? Before we get into the ATS, the implication for ATS as it relates to the Delta and the Royal Dutch issue. The Nigerian state itself is a very weak state. It's a very porous state in terms of structure. We are basically facing a state, as I provide a historical context, where you have weak rule of law, poor governance, a weak judiciary, and basically massive, massive corruption. Therefore, you can imagine when we then move to the issue of appellants and, of course, from the Royal Dutch case, the Nigerians now in the U.S. court seeking some kind of a remedy because of the futile attempt in the Nigerian court has moved them to a different environment and context. So the U.S. court itself is an excellent environment based on the revival of the ATS statute itself to seek remedy, yes, from the corporations. Understand the corporations as they function, if I can just regress a little bit, the corporations as they function in the North America or Western Europe do not typically practice the same values overseas. Because when you have a functioning environment where there is weak governance and the rule of law is very weak, there's less accountability. So clearly, the ATS case is one of those kind of, the ATS statute provides that legal environment to begin to seek redress. There was something I was reading somewhere about the issue of sovereignty itself. What does it say about the sovereignty in terms of Nigeria? Well, you know, the issue of sovereignty in terms of Nigeria, the Kiobel case does not challenge Nigerian sovereignty. I think the case itself goes to the heart of the atrocities of the corporation in Nigeria, more so than the sovereignty of Nigeria. But it does imply, at least says a whole lot about the Nigerian legal environment. If Nigerian citizens cannot seek remedy in Nigeria, I think that option clearly exists. That may be an example of what may come out of this case will send a lot of message to social corporate responsibilities in developing countries. Thank you.
So we have some decent amount of time for questions. If people have any questions for any of the speakers. Yeah.
So you guys mentioned how they're going. One of the reasons that the plaintiffs are choosing to go after the corporations is for the deep pockets, and also because they, as Professor Bradley mentioned, sometimes they can't get to the actual perpetrators. If indeed these corporations are mainly, in this aiding and abetting role, as what you guys claim, how effective do you think these ATS cases can be at actually solving the root problem, which would be stopping human rights abuses, where they are, if indeed we can't get to, or if the plaintiffs can't get to the real perpetrators and hold them accountable?
Do you want to start?
I think this is a really good question, an important question about how much effectiveness there is in these kind of sporadic judgments against the corporations. If there haven't been a lot of judgments, I should emphasize. There have been some monetary settlements, some of them quite modest. There was a $15 million settlement involving Ken Wiwa's son, who sued Royal Dutch Shell. But that's not a lot of money for a multi-billion-dollar oil company. You can't imagine that having a huge influence on its behavior. There's the threat of big damage awards in some of these cases, and certainly the corporations will factor that in thinking about investment decisions, I would think, and how much they get in bed with some of these regimes. But it's not all working in one way. I actually had dinner with Ken Weewa's son, who was the plaintiff in that case, and I asked him at dinner. I said, "What would you like to see now? You've won your case. You got a little bit of money." He said, "My next step is to try to get the oil companies to come back into the region because we really need the investment." And it's kind of an interesting answer, but it reminds us that it's not all, corporations, I agree, probably are much less accountable, and you have to worry about their conduct in areas where there just isn't a lot of supervision. On the other hand, if they decide to respond to these cases by basically disinvesting in certain areas, particularly these really poor areas, that can also hurt the people because the revenue streams will go away. Or what's really likely to happen, the way this is now happening, corporations that are somewhat even less responsible, who just happen not to have a lot of ties to the United States, will be the ones going in. And U.S. corporations have been complaining about that, Exxon and some of the big U.S. companies, because if you don't have contacts in the United States, you can't actually be sued under the Alien Tort Statute. So this is an incentive to get away from the United States and potentially to disinvest in ways that sometimes the population actually might also be harmed by. Those are very difficult trade-off questions. And then your question, balancing against how much deterrence or change in behavior we might be getting through the litigation. I'm skeptical that that this is the best global way to kind of get multinationals to act more responsibly. I would prefer to see some more comprehensive approaches, whether it be through treaty regimes, codes of conduct, and other things that go corporations to do some things more proactively rather than wait for lawsuits to happen. So there's just questions about how these companies are responding.
I'll just add briefly that building off that last point, that there are efforts underway to establish, so far they're at non-binding level, but persuasive codes of conduct and human rights standards for corporations. One can imagine, though, that you have this kind of choice. You could pull out, or you might then try to influence the behavior of the government that is the primary violator. A lot depends on the nature of the industry. How mobile is the industry? So if you're talking about child labor in the context of sweatshops, that's very mobile, and you can move from one country to another. If you're talking about extractive industries, it may not be so mobile. So it's worth keeping in mind it could be a sector-by-sector, industry-by-industry solution. That said, I could imagine a more sanguine approach, which would say, well, wait a minute, if you have multiple avenues, right? So the suits I was talking about in the second half of my remarks are against the government, right? And so if the government has a legal obligation against it, and the corporations it's working with have legal judgments against it, or the risk of that, they might partner together. Not clear that that's going to happen. I think Professor Bradley was gently sort of alluding to the fact that particularly Chinese corporations are coming into particularly Africa with essentially saying, what do you need? We'll do it, right? And we're not really interested in a lot of these other issues of corporate social responsibility or human rights compliance. So you have to look at the substitution effect as well. Good question.
I think in the context of American companies are likely to probably follow a code of conduct much stronger. I think, if I'm correct, the Nelms and Burton Act pretty much provided much stronger enforcement in terms of the behavior of American companies. But understand the European companies, it's a field day for them in most parts of developing countries, especially in Africa, where they've been part of that colonial history for a long period of time. So there's less accountability that you should expect from European companies, it seems like. That's not to suggest that they don't have their own code of conduct, but I think the enforcement is much, much stronger, and there is much kind of a retributive justice that may be coming to American companies that doesn't behave accordingly. We have the chevrons there, and Chevron has a social a social responsibility kind of a program that's been going on in Nigeria for a while. So really, the Nigerian government itself needs to go through its own process of socialization, and I think it's an evolving democracy, and there's a lot of massive challenges in terms of even going to the court in Nigeria. It's a nightmare to seek justice for basic civil suit or even criminal cases. Cases can go forever, and a lot of adjournment takes place, and therefore it's a very, very predictable environment in terms of where we are now in Nigeria. That until that socialization take place to true democracy, even for our country over here, we're still an evolving and a developed democracy, but democratic principles hasn't quite consolidated as it is over here in Nigeria. So the environment presents a challenge. Yeah.
Any other questions? Yeah. Tara.
Professor Helfer, you mentioned that U.S. courts have taken a broader view of universal civil jurisdiction than that's been accepted in the international legal community. So do you think it violates international law for U.S. courts to apply the ATS extraterritorially the way they have since Philadelphia?
So great question. You're putting me on the spot with that. So I have to say that a couple of different things. It really depends on how close of an analogy you want to draw between criminal and civil jurisdiction. And I think it's that analogy on which this is going to hinge. So there's no doubt that there is a movement to have universal criminal jurisdiction for a small subset of peremptory norms, human rights violations, torture, slavery, genocide, crimes against humanity. There are a few others in that as well. And so that's widely accepted. Then the question becomes, what does that implicitly, what does that allow in terms of civil remedies? Because after all, we're talking about criminal activity or international criminal activity for which there are victims who have a variety of different kinds of claims. I mean, they may have a moral claim. They may want to see someone who subjected them to physical abuse or torture to be punished, but they also have damages, right? And so the question, I think, comes down to, we don't have a clear rule that specifically says universal civil jurisdiction is problematic. So the question is, which analogy do you want to draw on? What the European governments that have intervened in Kiobel have said is essentially, look, universal civil jurisdiction can be a backstop when other bases of jurisdiction aren't available. So if, for example, you can't get remedies in Nigerian courts, if you can't get remedies in Dutch or British courts, then it should be okay as a kind of fallback to go to another legal system, and it could be the U.S. legal system for civil damages. I don't want to say that, Tara, that the points are settled, but I think that's probably how international law is likely to evolve. That there will be a kind of universal civil jurisdiction as a backstop to other forms of jurisdiction.
Other questions? Anyone? Well, I'm going to take advantage because I have a question. We've seen in various cases the court sort of displaying very different attitudes towards discussing the role of international law and influencing its own decisions regarding related questions. So I was wondering if what maybe Professors Bradley and Helfer see, or what kind of a role you see for international law in a discussion of these issues and sort of how that might be addressed by the court in this case.
Sure. It's a good question because one of the things that's happened, certainly since I started teaching about 19 years ago, is certainly an increase in the number of cases in the lower courts and in the Supreme Court that involve these questions of international law. So this is becoming a much more common phenomenon. And you were, I think, adverting to the fact that in some of the constitutional law cases, for example, some of the justices have been quite resistant to the idea that we should interpret some of our basic rights guarantees in light of international or foreign materials, European norms and the like. Interestingly, some of those same judges are reasonably receptive to international law in other contexts. And so Justice Scalia, for example, has quite complained about in using international law to interpret the U.S. Constitution. But if you give him a treaty case, he actually, way back in his academic lifetime, he's actually kind of a comparative lawyer and is quite comfortable looking to foreign precedent in cases, in statutes and trying to figure out what the treaty means. And he appears to think that's a perfectly appropriate judicial activity. And even customary international law, which is always harder, I think, because it's not written down and it's harder to know what it is. The most famous case in modern times about whether we pull American law back based on customary international law is an antitrust case from about 15 years ago. It was Scalia in dissent saying, how come the majority is not thinking about international norms to pull back the statute? There's a lot of customary limits on extraterritoriality. So it depends very much on the context, I think. Yeah. But in general, I think the court is getting more comfortable. If you think about the war on terror, the Geneva Conventions are coming into those cases. They're seeing a lot of these issues now becoming more of the staple of what they should become comfortable with, and it really then depends on the issue.
Yeah, and the only thing I would add is that I think it's very important to distinguish between, in addition to distinguish between the sources that one's interpreting, Constitution, treaty, statute, customary international law, to distinguish between international law and foreign law. I think that U.S. lawyers for many years had a view that it's kind of, there's our law and then there's everything else, right? And in fact, turns out that's not true. International law is very much part of our law, although it's mediated in a variety of different ways. Foreign law is not part of U.S. law, although it could be a rule of decision in a number of cases. And I think where the Supreme Court has sometimes gone awry is sort of conflating those two, trends in comparative law and foreign law, as opposed to what international law treaties or customary international law provide. And so I think one thing that is going to be important is for the court, to the extent whatever it's looking at, whatever document it's trying to interpret, that it keeps that distinction in mind. And I think that will help to clarify the different sorts of roles.
I just want to quickly add that we're probably going to see a proliferation of human rights cases in the American court system. Over the last few years, we've seen what has been taking place in the context of civil wars and folks who are violating human rights in domestic conflict in foreign countries. Now some of those issues have been addressed in American court. I think the one that comes to mind to me was the case of Charles Taylor, who Taylor has a case going on in The Hague at the moment. And rather than go after Charles Taylor, there was a lawsuit that was brought against Charles Taylor's family, particularly his son, Chucky. And Chucky was very, notorious during his father's regime for killing, cutting legs, and just, going on a rampage. And I think it was in the Florida court that the decision was made, and he's facing, I believe, a life sentence or what have you, in close to that in U.S. Jail system. So therefore, as more of these cases are coming forward, the precedent it's been established for others to bring cases or find remedy in foreign courts.
Great. Yes. Maybe this will be the last question.
Would there be scope for introducing some international arbitration procedure in these cases, just as we have in commercial law?
It's a very interesting question as to whether that would be possible. So first, the arbitration proceedings are consensual, so you would need to have some sort of mechanism whereby parties that would be at risk of being sued in human rights cases would agree either in advance or, at the time of suit to an arbitral procedure. It strikes me that there's not an awful lot of incentive for countries to do that. There also are a growing number of public international mechanisms, courts, tribunals, review bodies, that I think that arbitration would serve the same function. So I'd have to think about what would be the advantages of having an arbitral system for these sorts of public law or human rights cases as compared to the existing mechanisms that we already have, and whether, even if we establish a mechanism, is it something that governments are going to be willing to sign up to? So it's an interesting question, and it is quite striking that we have lots of international arbitration in the commercial and trade and investment area, and virtually none in the human rights area.
Great. Well, I'd like to give a big round of applause to our three speakers. Thank you very much.
Produced by Duke University. Online at duke.edu.